Yes.
May I please, Your Lordship? Lordship, in respect of item 8 to 14, Lordship, yesterday I have given an adjournment. Lordship may take it up next week or any other day after 2 weeks.
We'll have it on 30. Item at the request of council to state by the not objected to by the council. Yes.
Okay. Lordship, from item number 11 to 14, there is an interim order.
Interim orders, if any, will continue.
Obliged.
Anything more?
That acquisition, madam. The more means, was kindly had to look to
National Highway.
the lordship was referring madam DD2 and how to resolve the conflict 3H2.
Yes.
D2D minus 2, your lordship already on the publication of the detailed declaration under section shall best authority the government. Right. Then kindly come to 3E minus. 3E, capital E.
3E. Yes.
Power to take possession. Where any land has vested in the central government under subsection 2 of the 3D minus. And the amount determined by the competent authority under subsection 3G with respect to such land has been deposited under subsection 1 of section 3A with the competent authority by the central government. The competent authority may, by notice in writing, direct the owner as well as any other person who may be in possession of such land to surrender or deliver possession thereof to the competent authority or any person duly served within 60 days of the service of the law. That has not been done till today.
They have not.
Yeah.
You have not issued notice, Mr. Sharp.
No. And we are having the land parcel, so many tenants are also there, my possession. It is especially.
Okay, then they will, if it has not been done, then they will follow the provision.
That is the let them follow. I am not saying, madam.
We are not on this issue. We are
That's
on
right.
this issue of 3H2.
That's true.
That was the controversy.
That's true. 3H2.
So 3H2 will be subject to, will have to be read in terms of 3D.
Subject to the compliance of 3E, man. 3 and 3E also.
3D and 3E. So, this 3H2.
Yeah.
Sorry, 3H1.
3H1. Here it is written 3H1, man.
3H1.
Yeah, 3H1.
So this determination under 3G.
Yeah.
This taking over possession.
Yeah.
Is taking over possession from the government.
No.
Not from you. Because
no,
under 3D.
By the tenant owner who may be
3D2.
Yes. No,
it already vests in the central.
Already best, right? Best.
Already vests.
But there, with reference to them, when land has been vested in the central government, your lordship, under subsection 2 of section 3D, and your lordship, amount determined by the competent authority under section 3G with respect to such land has been deposited under subsection 1 of 3A with the competent authority, the competent authority may by notice in writing direct the owner as well as any other person.
Where you're reading from?
I'm getting PE subclause 1. PE subclause 1.
TE.
This follows 3D. 3D says it vests.
Yes, and then thereafter, the notice in writing direct the owner as well as any other person who may be in possession. In my case, so many tenants are there. Possessions are there to surrender or deliver possession. They are up to the competent authority. Best
So if they have not issued,
right.
they will issue it.
That I'm not denying my provision. I cannot. Let them comply this provision, my lord. I have nothing to do.
No. Your prayer was before the amount is further determined by an arbitrator.
Right.
If there
Now,
is an
that-
enhancement of the amount,
Now that was the my lord
until
idea.
and unless that is deposited,
Right.
possession cannot be taken over. That was
Right,
your
sir.
submission.
That's true, my lord. Thereafter, your lordship has pointed out that one. That part gone because arbitration.
So therefore now we want to know whether you accept.
Now that
what
part
you
your
has
lordship is
compromised.
keeping that open. Arbitration part keeping that open because we have already submitted. Other they have
We are
just
not keeping it open, we are deciding it.
no, my your lordship because arbitration clause is there, my lord.
No, arbitration will take its own course.
But
Once it is once
so your lordship cannot give any finding on that, my lord.
on which
On the amount which may be determined by the
amount we cannot give.
Right.
What we want to say is this 3H1,
Right.
which you pointed out the last day, that the possession can only be taken over after the amount has been deposited, as determined under 3G.
That's true.
So 3G will also, according to you, will also include 3G determination under arbitration.
No. Yes, that is
That is your submission.
my submission, my. The submission and arbitration may be made in Supreme Court, even some time limit is given to the arbitration. You decide within such and
We'll
such.
provide the time limit and everything. There's no difficulty on
Yeah,
that.
that is also.
But to say that until it is concluded and until the arbitration award refixes your compensation amount, you will not hand over the possession. That is not acceptable.
Subject to what you say. What I find otherwise 60 days is there, my. Suppose your lordship initially directed them within 30 days, they are to my lord decide the matter. That we also, it is within 60 days, everything will be over, my lord. My lord.
Yes. Anything more?
Lordship,
He submits that notice under 3, he has not been given.
Lordship, may I read the notice in vernacular?
Is it here? Enclosed? to the
No,
petition?
Lordship, the instructions we are directed to in the instruction,
You
but
have
this is
already issued the
regarding the
notice.
making payment, Lordship, but here one line is here. ইয়াৰ দ্বাৰা আপোনালোকক, that is, this letter is addressed to the Masuda Khatu, the present petitioner. জনোৱা যায় যে ওপৰত উল্লেখিত আঁচনিৰ সংক্ৰান্তত নিম্নবৰ্ণিত মাটি দি নেশ্যনেল হাইৱে এক্টৰ 1956 অধীনত অধিগ্ৰহণ কৰা হৈছে আৰু ইয়াৰ বাবে উক্ত আইনৰ 3G ধাৰামতে আপোনালোকৰ ঘৰ জিৰাত পুখুৰী আদিৰ ক্ষতিপূৰণৰ ব্যৱস্থা কৰা হৈছে সেয়ে আপুনি আপোনালোকক ক্ষতিপূৰণৰ টকাখিনি গ্ৰহণ কৰাৰ বাবে নিজে নাইবা কৰ্তৃত্ব প্ৰদান কৰা ব্যক্তিক অহা ইংৰাজী ইমান তাৰিখৰ ভিতৰত তলত উল্লেখিত প্ৰয়োজনীয় নথিপত্ৰসমূহ দিবৰ কাৰণে this is the notice issued whereby it was stated that the land has already been acquired
When
and it was issued on 8/7/2024
8/7.
8/7
It was issued.
No, notice does not say give possession. They are saying come ready with the document.
these are certain
You will consider
technicalities
that. No.
if there
No,
It is for
agreed-
payment, my lord.
This notice is under 3E.
is
Yes. It says, my lord, may second to surrender or deliver possession. It is here only about the document.
May I submit, Lordship? The land has already been acquired. It cannot be taken back
That
or
I am not
cannot be
saying.
returned to
I
the
don't
petitioner.
need the land, my lord.
May-
We are also
may
for the
complete-
interest of the government. my
may
lord.
No,
complete
he
with
submits
due
that there
respect
are
to my
some
senior. Here now the
settlement
question
over the
is
land.
whether they will get an enhanced amount or the amount fixed by the competent authority. That much,
It is
Lordship.
to be determined by the
The arbitrator. They cannot take away the land again, but we cannot give the return back the land. Land has already been acquired. Now the question lies only on the payment part, enhanced payment or the payment already determined by the competent authority. If the arbitrator says that yes, they are entitled to get some more amount, then upon that they are also entitled to get 9%.
All right, you give us a copy of that notice.
Lordship.
You have received that notice.
Yes, I'm having this notice. This is not the notice which my is envisaging that.
Whatever it may be,
Yes.
you received the
This
notice.
notice say that your ক্ষতিপূরণ not your lordship আপুনি আপোনাৰ ক্ষতিপূৰণ টকাখিনি গ্ৰহণ কৰাৰ বাবে অহা 17/7 তাৰিখৰ ভিতৰত তলত উল্লেখ কৰা প্ৰয়োজন নথিপত্ৰসমূহ জিলা আয়ুক্তত ভূমি জমা দিবলৈ জনোৱা হ'ল। Everything is there, man. But thereafter, because possession in my land, I have stated in paragraph 5, so many tenants are there, man.
Mr. Chaudhary,
Yeah,
your possession is not to be determined now.
right.
It already stood determined after calculation of the compensation by the competent authority.
Yes.
So from that particular day, it stood vested on the central government. You are now to vacate the land,
I am to become the land, so you have to support the issue notice.
which is what this may be.
It is not the notice as
No,
per
no, no,
section
this may
3.
be a preclude because you have been notified the amount is there. Please come and collect it.
But 3E, this notice is not 3E notice, madam.
Whatever it may be,
No, madam, it is a statutory provision, madam.
no. The problem is that you are not going forward to the office to collect the amount. Why don't you collect the amount which is there?
Madam, before that, we filed before
Whatever it may be, you.
being dissatisfied, we filed before the
No,
arbitrator.
no, no. Then we are directing them that they will issue notice, take steps to vacate the premises. With immediate effect.
So my application will be about arbitration.
Your application will be decided.
So that is what it must be, your lordship. That also can be, it should be read along with that minor provision.
Not along with. Your application will be decided independently. If you are entitled, you'll get.
I'm not saying, madam, I'm not taking the land that cannot take.
Huh.
You take the position. You comply the section 3E.
Whatever it may be. It is already there. Your initial prayer is not there.
No, my
Your
prayer is
prayer-
only
Your prayer in the writ petition is
Yeah,
not a
compensation.
challenge to the, not a challenge to
educate
the
compensation.
adequate
that
compensation.
is-
We are directing that.
That is there, man.
We're directing. If you are aggrieved, you appear before the authorities.
Arbitrator. Already, my lord, last time also because of that, although this order is go, already we filed it on 1st of August. Yeah.
You file it, it will be proceeded with.
Yes. Already filed. If you will see again, you will file. Already filed, my lord. Before arbitrator.
If you have filed, you have filed. If you have not filed, we permit you to file.
Already filed. You also may accord it, no problem.
All right.
So,
Anything
Lordship,
more?
regarding that filing, Lordship, that question arose on the earlier occasion and the counsel for the revenue department, they have stated that it was not been filed.
No, it
So
was filed.
accordingly, there have been some procedure is there.
Yes.
I think that council told them how to file that.
It was filed online, they have stated. So we are asked to give the copy. That was already given.
They can very well find it out,
Yes.
Lordship. Everybody finds it out.
Yes.
Heard learned counsel for the parties. Yes, pass out it.
Much obliged.
Obliged.
Lordship, interim order में candidate
No, we are not continuing the interim order, but you'll decide the matter within 60 days. The arbitration.
Obliged.
This application is for appointment of arbitrator. And earlier occasion, I have been directed to furnish the entire tender document that I have wrote by way of affidavit. My lord. Now, my lord, my request is at page, my lord, 50. $55, my lord.
Page number?
55.
No, first show us the clause. Where is the clause?
Oh, close.
Application clause.
Yes, yes, my lord. Look at page 18. At page 18. Page 18, that is content, Milord. And the serial number 5,
Page 80,
18, 18,
18.
18. Serial number 5, Milord. General conditions of contract IAFW 2249, that is applicable, Milord.
You show us.
Yes, yes. Now, at page 30, at page 30, Milord.
Yes.
Close 50, Milord.
Hmm.
Arbitration. May I read, Milord?
Yes.
All disputes between the parties of the to the contract other than those for which the decision of the CWE or any other person is by the contract expressed to be final and binding shall after written notice by either party to the contract to other of them be referred to the sole arbitrator of an engineer officer to be appointed by the authority mentioned in the tender document. Unless both parties agree in writing, such reference shall not take place until after completion of the work or termination or determination of the contract under conditions so and so, so and so. Provided that in the event of abandonment of work, cancellation of the, these are the exceptions. And the first paragraph, that is the main clause, my lord.
Where is the work order?
My lord. Actually, work order was not issued to me. Work order not issued,
Yes.
but I have accepted. That is at page 31, my lord.
So without issuing a work order, how can you accept?
That was also, my lord, dispute.
Huh?
Because, my lord, there was a delay in completion of the work. And that one of the reason was like this, my lord. But they have said that you have accepted it, so no separate work order has to be issued. That was their ground, my lord.
Then what happened?
Thereafter, my lord, I have filed separate, different, various representation. There is a
No,
communication.
why the dispute has arisen? Why?
Because the work has to be completed within 6 months. I could not because of certain reason. I have written letter to them. They have asked document. I have produced all these things. And ultimately, they reduced 10% of my bill amount as a compensation for delay with the completion. And that is why ultimately at page 55, I have asked for Milord appointment of arbitrator.
Page?
Page 55. May I
Yes.
read, Milord? Subject in the matter of appointment of sole arbitrator pertaining to the dispute in respect of so and so, so and so, so and so. Whereas the above contract agreement was entered between our firm, Messrs. So and so, so and so, and so engineering representing the Union of India. Whereas certain disputes and differences have arisen in connection with the contract mentioned above between our firm, so and so, and the Union of India as represented by the Commander. And
When was this issued?
below
When did you issue this letter?
on 24/1/23. Thereafter, they did not do anything. Once again, my lord, At page 63. At page 63.
One notice is no, yes. Any objection?
But I just pointed out, I am handicapped because I could not bring my file due to yesterday's that incident. But what happened at page 42, annexus 7, para 3,
Yeah.
our response to is
Hmm.
no claim certificate without any protest during the submission of compensation bill in the above CA. And the next annexer, same paragraph 3, page 45, annexer 9. But in at paragraph 3, it is indicated. Actually, as per section 65 of the general clause of contract, no further claim after that determination of the final bill. That section 65 is at page 28. It is clearly in the GCC code, general clause of contract, it is clearly
You
indicated.
file your objection. Have you filed your objection?
No, here it was not no notice, nothing was.
No
enclosed.
notice,
They
yes.
CA was not enclosed. Subsequently, last occasion they filed the
All right.
CA.
Heard Mr. Sahul and Petitioner, petitioner seeking appointment of an arbitrator under section 6. The petitioner was awarded with a contract number so page number 31,
Milord.
which was accepted by the respondent authority. In terms of the provisions of the contract, because of reasons which the petitioner claimed was beyond his control, work could not be completed within the time stipulated. An amount equivalent to 10% of the sales rate was deducted by the respondent authority as compensation for default on the part of the petitioner. Complete the work as in terms of the contract. Stop. The learned counsel for the petitioner submits that the respondents were not entitled to deduct the amount. Consequently, since there was a dispute which arose, he filed an application under the provisions of the Arbitration and Conciliation Act, demanding the matter to be referred to an arbitrator and for appointment. So, the notice was issued on 24/1/2023. So, since the arbitrator has not been appointed, he can approach this court regarding seeking appointment. Mr. Goswami, A. Goswami, CPC, represents the respondent. He submits that he like to complete the time objection. Accordingly, let notice be issued returnable 4 weeks.
Well,
And the respondents will complete their instructions and file necessary objection. So advised. Extra copies be furnished to Mr. Goswami within a period of 1 week. Yes. After the returnable date.
Must have.
Or give a date after 4 weeks. Wait. Matter be listed on 13 September. 13 September. Yeah. Yes, Mr. Gwenka, where is your,
Lordship,
yes,
allow us further 1 week time to file written arbitration.
1 week further time.
My lord, as far as we are concerned, as directed by your lordship,
You filed.
we have filed an office. And my lord, the lead case is item number 5, that is Mukund infrastructure.
Hmm.
In that case, we have filed the compilation of case laws.
Yes, we have.
My lord, that may be treated as common compilation
For all the
for all the 5 cases. And
we'll have it on 6th of September.
6th of September, my
You wanted 2 weeks time.
lord.
For 1 week time. 1 week, then we can have it on 30th August. 30th August.
My lord, my colleague will not be here.
All right. Then
Which day? After 8th September, my lord.
all right. Then 13 September. It's on 13 September. And the respondent council renew their prayer for further time to submit written arguments. Prayer allowed is accordingly on 13 September as agreed to by both the councils. Councils for the petitioner have already submitted their written argument.
Regarding whether GST will be inclusive in the rate quoted by the victim. There, my lord, one guy has been submitted to the victim. The next one, circular of the, my lord, Ministry of Rural Development, Government of India. Some, my lord, workout have to be done by the department expertise, my lord, particular circular before it is worked up. I'd like to have instruction whether that was done or not before it is circular. So as per the circular, we are supposed to determine the GST, my lord, in conformance with the work.
How much time do you require?
What's to be posted after 2 weeks.
Mr. B. Gugoi, Leading Council Finance submits that some
It is a reply,
some uh, circular from the
6680
6/6/2018
of Ministry of Rural Development,
Ministry of Rural Development,
Government of India.
Government of
India.
India and received, which for on the
In the additional affidavit on 27/5/2024.
filed by whom?
By us. Petitioner.
Which is available on the additional affidavit filed by the petitioner. Stop. Gugoi submits that like he prays for 3 weeks time. Accordingly, he submits the affidavit after 3 weeks.
Affidavit in reply, not affidavit.
Affidavit in reply. filed.
Date may be fixed. Date may be fixed. That's the thing.
Any day convenient to this court.
Any date may be fixed.
Full hearing.
After 3.
6th of September.
Deeply obliged.
Supplementary for any.
Yes.
Lordship hearing was concluded in this matter.
This is covered by the matter, the other matter. No.
Bhatek.
Bhatek.
There they had in Bhatek only the difference is that lordship they have filed an application with reasons as to why there was delay, and here it's not that case. Lordship here already they have in the return shown that there is excess payment.
Where is the impugned order?
Page WPC 1430.
WPC 1430. ये लीड के हमेशा ऊपर या तो ये लगा दीजिए.
Page 36, Annex 5. Question of providing reason does not arise because they have not asked for reason. They have simply rejected the application.
Wait a sec. Neela, what was the rule?
29.
See, there is a provision for considering the reasons why, sufficient cause. That was not done.
Yes, Lord. That is not reflected,
That is
only
not
on the
done.
ground of late submission.
And what is, where is the form?
Form 37.
Form 37.
Page 418.
So at this stage, the matter should be remanded. Let them consider it, the refund issue.
That's the only
And whatever grounds you may have, we are not giving any decision on whether uh, we are
in
not.
fact, my refund application was processed.
Hmm.
At the stage when it, because of the quantum requirement, it has to go to the higher authority, above the assessing authority. When it reached the Commissioner of Taxes, from that level, they rejected it, saying it that application is time bound. Otherwise, the application was processed by them.
Hmm.
Till that stage, when it reached the, it crossed two officers, assessing authority plus the Joint Commissioner of Taxes, and thereafter the Commissioner of Taxes. Till then, did not find it as time barred.
From where do you say that? There is nothing in your affidavit.
Affidavit is vague on that, Lordship. For that,
Lordship,
your
only
Lordship
with
may
regard to the
have to take case in WPC 2833.
2833. Paragraph.
Lordship, coming to that. Lordship may turn to page 32, Annexure 4. Annexure 3 is the refund application. Annexure 4. Issued by the Deputy Commissioner of Taxes with reference to the above, you are hereby informed that the date of hearing on your application for refund under VAT for the period 10/11 is fixed on so and so. You are required to appear on the date positively. Then in Annexure 5, we appeared and we filed all the additional requirement documents which were called by the Deputy Commissioner of Taxes. This is the forwarding letter which has been received with all the documents.
Then,
Then again, Annexure 6,
what is this annexure 6 is the some,
additional date.
Huh?
Additional date for hearing.
okay, then what is annexure 7?
Annexure 7, Lordship, that time in the, because they were just giving dates for refund application, and in the meantime, for two other periods, they have already rejected as time bar. So under presumption, we came up before this honorable court that for this period also they may reject it. In the meantime, they have passed the rejection order, so that writ petition become infructuous, and thereafter we filed the present writ petition. So these orders refers to those that earlier writ petition we have filed, where the order your lordship will find at page 38. And the final order of this honorable court in that case is at page 42.
What is that page 38? Seeking a direction
Seeking a direction.
to give you the order, copy of the order,
Yes,
which was finally submitted.
which was finally submitted. And page 42 is the order date 3/3/2017. After receipt of the order, we were given liberty to challenge that impugn rejection order, subsequent to which the present writ petition has been filed. And the rejection order is at page 45, Annexure 9. Very similar reason.
Here no affidavit is filed.
No. Therefore, Lordship, just for the timing, come to Rule 29, page 304. Rule 29, sub rule 1, clause E.
1 minute.
Sorry.
Number?
Rule 29, page 304. Bottom down, clause E.
Hmm.
When the amount to be refunded is more than rupees 3 lakh, the prescribed authorities shall take prior approval of Deputy Commissioner before sanctioning such refund. The Deputy Commissioner shall not approve the refund if the amount to be refunded exceeds rupees 10 lakhs, but forward such cases to the Commissioner for approval. Where the amount to be refunded is more than 50 lakhs, the Commissioner shall take prior approval of the government before sanctioning such refund. So, because of this provision, the Deputy Commissioner has already taken hearing on that matter. He has verified all the documents. And because of this particular sub-clause of the rule, sub-rule, it was forwarded to the Commission of Taxes. Once everything is done at the prescribed authorities level,
No,
deputy
but
commissioner
where do
level,
you say that it was forwarded to the commissioner level? Is there any intimation? You have shown us the dates,
Yes. At the-
communications by which you have called for a hearing.
Yes, by the deputy commissioner of taxes.
And who is the assessing officer here?
Assessing officer is the assistant commissioner of taxes. It will be superintendent of taxes unit A, Guwahati.
Superintendent of tax.
Taxes unit A, Guwahati.
Mr. Counsel, what do you say?
Lordship, here it was indeed forwarded to the higher authority in
affidavit, they have
1430/2017. We have
For what purpose?
since the amount involved was high on the higher
So
side.
therefore, there was an inclination to consider the refund.
Yes.
my humble prayer will be Lordship to direct them to process my refund in accordance with law. That's my only simple prayer. Because otherwise the claim is not disputed.
We are not
Refund application is not
inclined,
disputed.
we are not inclined to direct them, because if we have to direct them, then we'll have to decide on whether you on your entitlement for a refund. There are two modes.
Entitlement is not disputed, Lordship.
There are two modes to dispose it of. One is to decide whether you are at all entitled to the refund. The other is that your petition was dismissed on the ground that it was time barred. But the rules say that you have an option to give reasons for the delay, which apparently, prima facie, it appears that you are not given an opportunity. We can set aside this order, remand it back for a fresh order. You tell us. If we have to decide on your entitlement, then we'll have to decide on the merits.
But in my humble understanding, Lordship, my entitlement is not disputed by the respondent.
To us, from which document?
They have only rejected on the ground that my refund application is time barred. My refund amount is not disputed. I am entitled to refund is not disputed. But only ground is application is time barred.
No.
Whether under the present provisions, can they say that my refund application is time barred? And the reason given that it will be deemed as self-assessment after a period of 7 to 8 years, they can deem something, and whether I will be able to go back and do or undo something which has gone in time. On that very basis, my claim of refund has been rejected. Otherwise, it has been scrutinized at two levels, at the level of the prescribed authority as well as at the level of the Deputy Commissioner of Taxes. At that level itself, before the prescribed authority or Deputy Commissioner of Taxes, if they have deemed so that application was time barred, they could have called for reasons, but no, it's an afterthought. Unless the very reasoning given by them is held by this honorable court as not tenable, by providing any reasons at this stage will not serve any purpose. And further, Rule 29 says the application can be rejected only in case of apparent mistake on record. They have not found any mistake on my record. They have not found any mistake in my claim amount. And if your lordship just follow the tabular sheet which I have provided on the last date, covering for all the 4 writ petitions,
Yes,
lordship on the sheet.
yes.
How they proceeded with my things, your lordship will come to know. But the first 2 column refers to assessment year 2006, 7, 7, 8. Here assessment proceeding was initiated by them but not completed. Not completing, after that I filed my refund application, and they say that since the assessment was not completed, the reasoning I have put it down below in the last column, as no audit assessment made within limit of 5 years, it is presumed to be a case of self-assessment. So refund application could have been filed within 3/9/2012, that is 180 days from after 5 years. Presumably, if I would have filed my refund application before that, and they have taken up the audit assessment, so my refund application goes on. I have to otherwise anyway wait for the assessment to be completed. But since they have not completed,
No,
now they are
is there a bar for you to file your refund application immediately after the returns have been filed within the time frame? Assuming you had
there is
filed,
no bar. There is no bar.
there's no
But
bar.
the refund application says from 180 days from the date of assessment or reassessment. So there has to be assessment to be complete.
So according to them, it is a self-assessment.
But they are presuming after 8, 9 years.
But you waited for all these years.
I waited just because they have started the assessment proceeding. So unless the assessment proceeding is done and the amount is finalized in the assessment made by the authorities,
All right.
because otherwise my claim amount is already reflected in the return. My claim is already lodged in the return itself. Lordship may just take up my return for the time being. Starts at page 23.
What are the judgments that you're referring for?
Judgment, one of the judgment I referred was Vartek Lordship.
Yes.
And another judgment was from the persuasive President Lordship High Court of Tripura, Agartala, in the case of Nandini Impacts, the division bench matter, where because of time barred assessment, the refund application was rejected. With similar facts and circumstances, the department could not complete the assessment within time limit. And just because it was not completed, they rejected my refund application on the presumption. So Honorable High Court of Tripura has said that that is not permissible. The operative, I'll rely upon paragraph 13, 14, and 15. 13 to 16, Lordship. May I read the paragraph, Lord?
We'll have to hear one more day. We'll keep it on 16th August.
Yep. Lordship.
16th August. Bench is likely to be available from 2 p.m. We'll have a little more time to hear it.
Lordship.
For further hearing on 16th of August. Mr. Toti and Mr. Chaudhary.